Exactly. Duncan, thank you. I know what first name should be. Duncan, thank you. Yeah, to their first commission meeting. Welcome. Glad to have you both here. Were you in a meeting in Capitol?
I was at the meeting, but I was in Baltimore in my daughter's basement with the barking dog. Remember that?
Yes, is
that what that was?
And let's confirm who we have on the phone. I know we have, let me see, Mr. Zonsky is on the phone. Professor Perry, are you on the phone?
Yeah, I switched from Zoom to the phone because it seemed better, but I'm here.
Great. PK, you're on the phone.
Yes, sir.
And is anybody else on the phone?
Susan Graby with the bars on the phone.
Oh, Susan, great.
Hello.
And, hi, Susan. Anybody else? You choose to remain anonymous. Okay, as long as you're not a commissioner, that's okay. So, public meeting order, I want to welcome again everybody here, including our guests, who will give you a chance to speak on the agenda items that you are here for, if you want to say anything on the record. So, it should be a fairly short agenda this morning. Mostly I wanted to get us together to kickstart a couple of new projects with Sandy in place now, and with a couple of work groups moving ahead. We are getting geared up to really get back into full production here this coming year, for which I'm grateful the transition is over. Things seem to be coming well, and you were going to say this before we get into the status reports. I'll just ask you to kind of tell us about what's going on in Eugene and how things are with, just to give us a quick report on your status and how you see things down there. Then we got status reports on some of the already approved projects, just to let you know what's going on with those. Again, a couple of new projects, and then that'll be it. We will have mention at the end of this meeting about needing another meeting, probably in a month or so, on the workplace harassment project to finalize our report on that. But
and likely that'll be a remote meeting, mostly just to vote on a proposal which will be given to you far in advance.
Yeah. Okay.
And we'll talk about that when we get to the update. Can I give you an update on Go right now?
Yep, go. Why don't you go ahead and give us kind of a commission overview and update.
Sure. So as most of you are aware, the transition did take a while from here at Willamette to UO and Eugene. I've now been working with the commission for about 6 months, which is kind of crazy for me to think, but it's been, I know it's not as busy as the commission's been in the past, but for me, it has been quite busy, mostly due to the work with 2 work groups. The first being the Workplace Harassment Group. I believe we've met 10 times now, and there's quite a bit of information. I did post a link on the information I sent to everyone of all the documents and all the work that group's done so far. We'll get an update during this meeting, but we feel very strongly that we'll be able to complete that work by the deadline which was given to us by the leadership of the legislature, which is the end of this calendar year. We had a very productive meeting yesterday. Mark, I know you were there, and we're feeling really good about that work. Very important topic, a great work group, really wonderful to work with, and that's been a huge part. Lane, as you're aware, chair of the probate group. We'll talk about that as well, but that's been moving along as well, and we'll have hopefully several bills to work with the legislature on in the next session with that group. And I don't know if that will be the end of the probate group, but you never know.
We're hoping people die naturally.
Overall, UO, we feel the bottom line of UO is we feel very supported. We've been given great support, whether it be through office space, technology, people supporting the technology. We have a faculty liaison group. It's a different model than when it was set up at Willamette. There is no faculty member who is specifically assigned to the commission other than the commissioner, Susan Garrett. But there is no one who is giving up any of their, their FTE time to work with it. That's my role. And then we have an advisory group of faculty members who are interested in our work. We had one meeting so far of that advisory group, I believe back in August, that Lane attended, to talk about different priorities. Hopefully we'll have a meeting there. We want to have this meeting here just because we know it's easier for commissioners. We really want to do here with get these new projects approved. Once we're moving, and I think will make a lot of sense involving students, we'll likely have not the next probably going to be in December, which will be a remote meeting, but our next full meeting hopefully will be in Eugene, when we'll have some students involved. And my goal is to have students through a fellows program, which we'd really like to set up, to involve with students who are interested in legislation, interested in the process, to be able to start with a new work group, so they can really understand those topics, hopefully with some of the projects which may get through today, or the ones which we'll re-engage on as we start this work. So we're really looking forward to the next calendar year to really get student involvement at UO, but overall, I feel tremendously supported. I feel that we found a really solid home, from dean to the associate dean. A lot of faculty members are seeing me around the building and really interested in our work. I know we've had some faculty candidates who've come through in the last few weeks, and they see that we have this program at UO, and they're really excited about that. So I think we have found a solid home. I feel very supported. Wayne, thank you for helping get me engaged in the group, and anything I can do to help, please let me know. It's all new for me. I'm kind of learning along with you all, but having the two workers I've been working with under my belt, I feel really strongly about it. And if you have any questions about the Progress Commission, let me know. But as of right now, I feel really good about it.
All right. Great. Any questions for Sandy? All right. And I guess before we go on further, just want to also thank Lynette for the use of the hearing room today.
I did
No,
want to
go home.
I never neglect that, and just to be clear for the record that everyone at Willamette has been incredibly supportive to make sure that we're able to have the room, which needing to meet in Salem due to the proximity of a lot of the folks in the group has been really essential. All the support staff here have been wonderful. Dean Williams, thank you so much for your assistance as well. So I just want to make sure that everyone knows the transition happened, but Williams has been tremendous support.
Yeah, thanks. Okay, let's go ahead and jump into our list of reports here. We have first collaborative law. This is, as you may recall, it's the Uniform Act on collaborative law. We approved it actually, so it's not up for approval, but when we approved it, it was subject to getting some kinks worked out between the proponents of the proposal and the bar. And we had a program committee meeting here about a month ago. And the good news was that those kinks seem to have been worked out so that we are ready to move forward with collaborative law. Anything you want to say about that?
If Susan wants to comment on the bars.
Okay, Susan, you want to go first, anything?
Hi, thank you. This is Susan Graby with the Oregon State Bar, and I appreciate the willingness of the Law Commission to give us a little more time to work out the issues that we had. And I think we've come to a good place and discussed at the last meeting, the program committee meeting, that if we can work together to develop the statutory language and at the same time work concurrently to develop the rule of professional conduct, to address the disqualification provision, we will be.
Okay.
Thank you very
Oh, she said you will be what?
much. I'm sorry if I cut out. We're happy to work with the Law Commission in this work group endeavor, and we thank you for your patience and willingness to let us have a little extra time to work out the rule of professional conduct issue.
Well, and Susan, thank you for being diligent about working that through so that we can move forward with this collaboratively, as the case may be.
Sure.
Yeah.
I'm Angela Laidlaw, and I proposed this project, and thank you very much to the Commission for approving this project. I sent to Mr. Weintraub and Ms. Brady yesterday a list of people that I thought might be good members of a work group that have, insight that might be helpful. Some of them are litigators, some of them are primarily collaborative practitioners. There is also, if there's a divorce coach on there, so a mental health professional and a financial professional also. So I have sent those names. There's one name that I didn't add that, and my husband actually and my business partner might be a good person to be on that. He's also an attorney, and as I was driving here, I realized he's heard me griping about all the things in my cases that are not working, and so he might actually have a good perspective as well. He's a family law litigator, so Alex Laidlaw is his name.
All right, so we will be going ahead with the formation of a work group on collaborative law against the Uniform Act, so it's already drafted. It's a matter of going through it and aligning it with Oregon drafting style and any other particular modifications that we want to make, trying to maintain as much uniformity as we can, typically in our Uniform Act. But it's, we've got the model already in front of us. So I guess I would just ask, you don't need to raise any hands now, but if there's anybody who would be interested in chairing the collaborative law work group, we're looking for a chair and a reporter. And, or if you just want to be on the work group or want to recommend somebody or nominate somebody to be on the work group, let me know. But otherwise, we'll go ahead and get that one rolling. Okay, any questions about collaborative law? Collateral consequences, I'll just take that. You may recall this is another Uniform Act. We have had this in the legislature, I think, 2 times, maybe 3.
Mhm.
The thesis of the act is inarguably salutary. It is that when someone is convicted of a crime, we know that there are immediate or direct consequences, such as fine and imprisonment, but there are hundreds of collateral consequences in our administrative rules and statutes related to the impact on ability for a license, a permit, related to occupation or employment, sometimes housing, certainly to citizenship. And these collateral consequences exist they're not varied, but I mean, they're just not obvious in administrative rules and other statutes that are not regular part of the criminal code. And so the concern was that people should be advised, certainly before they enter a plea of guilty, about these other collateral consequences. And we have always been able to get this bill through the policy committees. Thank you, Senator Brzezowski. It has fiscal impact because it requires a state agency, somebody to compile all of these various sources of collateral consequences and then develop a compendium of them and then update that on an annual or biennial basis. And so this bill has always found it in Ways and Means on the fiscal impact. There are also issues in the first part of the bill is basically notice, just making sure that somebody has notice of these collateral consequences, and that's the part that takes the assembly of this compendium of other rules and statutes. The second part of the bill, of the act, deals with its remedial relief from the collateral consequences. And you know, to be honest, my sense of this one is, at least until we get a signal that we are in a better budget circumstance with more funds available for this, I'm inclined to just kind of let this one lie dormant for now, rather than use Sandy's time and our resources in the legislature to push this one uphill again. I think it would be nice to on this kind of session. It's a great act. Someday there may be an opportunity to take it off the shelf and dust it off and push it through, but I think probably not in this kind of session. So unless there's a strong urgency to get this one through, my sense would be just let this one lie for a while. It's already drafted. It's just a matter of making a decision to invest the commission resources and time to push it through, given our experience, particularly in the Ways and Means Committee. Maybe after Sandy has been here for a couple of years, has good, strong relationships with all the Ways and Means Committee members and legislative fiscal office, and can do some interesting cajoling and maybe another story, but I hate to throw into that in his first legislative session. Direct criminal appeals. Sandy, do you want to tell us what's going on with that?
Yes, and I know that Jim is here to speak about that as well.
Yeah.
This was discussed at the program committee. It looks like there's a lot of momentum on doing 2 things. One is, I don't know what to call it cleanup, but it's an addition to the work that this group had, group had done in the last session. And Jim, I'll let you speak on that specifically. And hopefully with the goal of having potentially a bill in this session for that piece of it. And then to engage on the part 2 of direct criminal appeals, which will be largely focused, from my understanding, municipal courts, which is something that just having spoken to colleagues throughout in our law school and otherwise, something that's an interesting issue here in the state, and one that we hope to engage. I know there has been some interest since we kind of put out a call for people who might want to join that group on some of, in terms of chairs, in terms of people who join that work group. So I think that of the work groups that we're going to start, this will be one of the, I wouldn't say easiest, it'll be one that is most ready to go.
Jim? Come on up, yeah, go to the table.
Thank you, Chair. Generally, on the first topic of special statutory proceedings, well, to back up, last year's, 2 years ago, Director of Appeals Work Group, the issue of whether one can appeal from a special statutory proceeding, and if so, what are the standards of review and so on, came up, but the work group felt it didn't have enough day-to-day work with those to feel good about proposing legislation. So the thought was to recommend that we continue meeting this year. And I understand that our chair, Judge Bouchon, has again volunteered to continue chairing that. And I appreciate that if that's true.
It is now.
I'm just trying to finish a memorandum that kind of summarizes, okay, what are we talking about when we use the term special statutory proceedings? There's such things as expungements, return of evidence seized during investigation of a crime, civil forfeiture, a whole variety of things that come up in the context of a criminal case. Sometimes they sound criminal and sometimes they don't. And right now, it's not clear whether they're civil, whether they're criminal, and if you appeal, which rules apply to it. So we hope to sort that out. And I hope that the memorandum will contain a couple of proposed legislative solutions. Of course, I got any of those, but at least there'll be something for the work group to start with. The other issue that last year's work group struggled with was appeals from municipal and justice courts. If one were to map out, I think, what an appeal from a justice or municipal court through circuit court to the Court of Appeals to the Supreme Court, with having both justice and municipal courts of record and those that are not courts of record, I think it would look like a map of the Los Angeles freeway system. Our hope at the end of the work group is that it will look more like a map of I-84 going through eastern Oregon. Just figuring out where you appeal and what remedy you use is challenging, and it's particularly challenging because most of the people in municipal and justice courts are not represented by counsel, and so they're having to figure this out on their own. So one goal is simply just to make the rules clear. How do you appeal? Where do you go? The other aspect is what can you get review of? And right now there are limits on what you can, or at least there appear to be limits on what you can get review of, and I'm not sure that those are really clear. And so maybe we can take a look at that.
So is the plan would be, if you can, to have a bill on the special statutory proceedings for the coming session, and then the municipal and justice appeals after that?
Yes, I'm doing everything I can. As I said, I'm putting together some proposed legislative language, like 3 different options, and hopefully the work will select one and get and away we can go.
Judge Bouchon.
So a couple of comments. Since the work group last met, my life changed in that I'm now the presiding judge in Multnomah County, which changes the demands on my time quite a bit. That I'm still willing to work on the continuing work of this work group and willing to chair it again so that we can complete what we were hoping to complete last time. The municipal court piece of it is suggesting maybe that should be a separate or a work group with a different composition, because the current the work group that came up with the direct criminal appeal bill, really deal with municipal court appeals very often. At least most of the participants in that work group. And I think we need some practitioners in that area, and perhaps even a different chair, since I don't have a municipal court in my county. We are the municipal
You are the
court.
water board, yeah.
So it's, that step of the appeal process is non-existent in my county, one of the few counties in the state that doesn't have a municipal court. I'm wondering if maybe what we ought to do is have the continuing direct criminal appeal work take on the first piece, and then formulate
Send in the next team.
Yeah, send in the next team to take on the second piece.
And I think that makes sense. To be honest, I would be pleased to have you continue to share that as well. I do understand the demands of your time, so I'll take your advice on that. But it is true. I mean, I sat with that direct criminal appeals. Those are not municipal attorneys, the justice attorneys. So because what we're talking about now is getting cases from those courts to the circuit court and then on that, which is
Right.
The first part is just hard to fathom. Statutes. Have you done that before, Mark?
Not recently.
Yeah, it's you're right. That's a good analogy. Things so I have put out a call to the Oregon City Attorneys Association and to Carl Myers, who's the municipal judge in Kaiser, and also obviously the government relations person for the justice and municipal court judges, I think, still. And so we're the names of attorneys that practice in that area. That's what we constitute the work group for that when we get this thing.
And we've already had some interest.
Yeah.
Three people so far have gotten back to me saying they are interested in serving on that group. So it's one that I think we will put together.
Great.
Mr. Chairman?
Yeah.
Comment?
Yes, you're right.
And this is just a general comment in the area. First, I'd like to applaud Judge Sean and Mr. Nass for taking this project on. You know, any attempt to simplify, in my opinion, a good thing. I read Mr. Nass's memo, and it almost seems as if this whole area is more akin to an integrated circuit that is so complex that it could potentially become a trap for the unwary. And as a litigator, I'm concerned about two things when we're looking at hyper-technicalities. One, are they traps for the unwary? And especially in this appellate realm for appeals, notice of jurisdictional, some instances, any way that we can avoid malpractice traps to me is a good thing. The second thing is that sometimes we lose sight of the fact that hyper-technicality increases the cost of representation to the client. And, you know, to the extent that we can make things simpler, I think we can do a service to the consuming public, public who consumes legal services, because, you know, we can eliminate 5 or 6 hours from some of these bills trying to figure out how the technical process works. That's a good thing. I want to applaud you, and I hope that,
Yeah, that's actually the comments. I was just curious from Judge Egan and Justice Bunting, have you had a chance to see our latest work product on direct criminal appeals in action yet? No, I'm sure you've not.
We have some issues around.
Have you? Oh, okay, all right. Well, when it's up now.
Yep.
All right, I will be to do, you know, those cases make their way through, kind of the road testing would be work with me of the last. So, all right, so then, just a report there, we will then plan on getting the group back together for the special statutory, proceedings. See if we can get a bill in time for the legislative session on that, and then we'll constitute for the balance of work. Yeah.
I just, in terms of the makeup work group, things have changed a little bit. Then Court of Appeals Chief Judge Erica Hadlock is no longer Chief Judge.
Yeah.
And I don't know, Judge Egan, if you've given some thought as to whether you're going to ask Judge Hadlock to continue with that, or whether you would take on that role. You know, it's kind of your call, but it's very helpful to have the Court of Appeals participate on that.
For the sake of continuity.
Yeah, I think that's a good idea. And then the other piece is the Department of Justice representative on that work group, Andrew Lavin, no longer at the Department of Justice. He's a judge on my court. So DOJ is going to need to nominate a different representative, which I assume they will. And I don't know, Jim, if you've had some talk with them about that or not, but that's something that they'll need to work on.
I think the gentleman who represented the District Attorneys Association also has moved on, so we might.
I think that's right, yeah.
Why don't we just remain that? It'd be so much easier. I know. You're still here. I'm still here. Okay,
Mr. Chair,
Yes.
this is Floyd. So the new representative for ODAA is Amanda Dalton.
Okay,
Excellent, thank you.
we'll reach out to Amanda then. Great.
I'd just like to point out that I coached Amanda Dalton at basketball when she was in middle school. I'm not sure whether that was working.
How was your jump shot?
Well, first of all, she refused to wear her glasses on the court, so she couldn't see the basketball, but she never hesitated to shoot.
Yeah, let's make sure that gets in a minute. Okay. Then Jim, I think that's it then.
Thank you.
We're moving ahead. We'll get that scheduled and look forward to a bill from your good work. Thank you, Sean.
Yeah, I'll be in touch, just real quick, I'll be in touch soon, but, Mr. Jackson's already given me some dates that he's available, November, I'll probably reach out for December as well, just be Sean, I'll reach out to you.
Okay, great. All right, hearsay. Keith, this was one you were saying, was it not?
Correct. Just coincidentally, I wrote an article on admissibility of tweets and Facebook postings about a year ago. Kind of stumbled onto this conundrum, and it is an interesting issue. I'll admit that I'm not a visionary and don't really understand what kind of technology we're going to be facing in the next couple of years. I mean, I still don't understand Snapchat, but those are some of the issues that the courts are wrestling with now. And so I said I'd be happy to help chair this or co-chair this. I think the idea obviously is first to identify what the problem is, because not all of us understand it. But in practical terms, you know, we're talking about evidence that is of a digital nature that may be of a temporary nature. It may clearly, kind of like the old Mission Impossible tapes, evaporate after 24 hours, but it's still evidence, obviously. We're not, or certainly at this point, not aware of whether any other states have tried to address it. I assume some people have looked at it, so we'll figure out what they've done and then identify areas for improvement and then come back to you with some proposals. The idea is that we're going to need somebody who's a visionary, and I've been talking to some people maybe at Intel, actually have an idea of what's coming down the pike so that we can maybe start addressing it before it rolls over us. We're clearly going to need somebody with a good understanding of the evidentiary code, somebody that represents the judiciary who has maybe wrestled with some of these problems. And we're clearly going to need somebody from both the criminal and the civil side of the practice, because the issues come up in every realm.
I think it sounds fascinating. I was interested in this when we first heard it, and I'm glad we're in a position now to get it work together. And I think that's fine. First meeting or two or three, a scoping meeting, just to determine the size of the issue and what the specific questions are, and after that, moving into drafting. I don't know, Judge Bouchon, is this an issue that has been in your courtroom?
Yeah, it comes up in, and I was going to say, in both criminal and civil cases. And if you're looking at the Oregon Evidence Code and maybe crafting a special provision that would address this type of evidence, that probably would be a good thing, because right now we're using the existing rules that don't always fit.
Right.
So.
Oh, it sounds like fun. Okay, good. Well, we'll get going on that. Yeah, and I like your idea looking forward too, anticipating maybe, have to deal with holograms in the witness box or something like that.
This is actually one that potentially on the front end, get some lawsuits about this research.
Sure.
And I'd be happy, that's one that I'd be happy to, I'm certain that's actually an area that there would be students to be interested in. So if we want to have a conversation about that, and I can reach out to our pool of students, even before we can even work, just to have a baseline, I'd be happy to do that.
I'm kind of excited to hear you say, and I'm assuming your research for your article, that you must have determined that there is not a lot of legislation out there on this.
There's not, and it's really fascinating how the courts have addressed it. I mean, as Judge Bouchon said, they're trying to, exactly, they're trying to figure out, okay, what rules apply and how does this unique evidence fit? And then you've got issues about identification and proving up, is it a true and correct copy? Simple things like that we deal with in a paper context are completely different in a digital world.
Great. Well, what's exciting about that is that we can get this figured out. This might be something we propose to the Uniform Law Commission as a uniform. And we think we've got a good solution to it. So that's to be on the front end. Good. All right. Any questions on that? Next, probate modernization. We're meeting in a room at the Capitol now that is identified by a sign, a large sign that says exit. Appropriate both for the subject matter and also for about where we are in this project. It's time to end. But I think we're getting there. In this session, we are dealing with some very, very interesting issues. Sometimes the closer you look at the law, the more marvelous it is that it works. We just do by convention and by assumptions. Sometimes we don't find in the code. And that is true with regard to small estates, which is the subject matter that we're dealing with right now. Wrongful death proceeding, how to handle a wrongful death case. And if you've ever done that before, but a wrongful death claim is filed by a personal representative, but it is not an asset of an estate. Beneficiaries of a wrongful death claim are different than the beneficiaries of a will, for instance. And the nexus between a wrongful death proceeding and a standard estate proceeding is not clear. We're doing some great work to clarify that, and also we're at personal injury claims that are assets of an estate. That is, if an injury claim that did not result in the death of the decedent, still is an asset of the estate. So we're trying to clarify the difference between those two and the procedures that pertain in pursuing those. And the other area I think we're going to be able to fix is an issue where a probate is necessary, maybe to prove a will for the purpose of exercising the power of appointment, or accessing medical records, or by consent to something or another, but there's no assets. There's no assets. You're doing it for some other purpose. You need that will proved. You need the authority of a personal representative, but there aren't any assets in the estate. Well, under the current law, we don't recognize no asset probate. Once you're in, and you go through the publication, you go through the notice, you go through the accounting. It's all, a lot of work, just like you were talking about, a lot of work for no benefit and process. So we're devising basically a no asset estate process where you declare at the beginning that you're filing a petition. We have no asset that excuses you from the bond requirements, that excuses you from the publication, newspaper publication, and excuses you from inventory, and even excuses you from accounting as long as no assets appear during the course of the estate. If assets do appear as you're administering, as which sometimes happen, then you kick into the regular process. But if you've got if you're probating a will for a very limited purpose, and no assets are in the estate and never do come into the estate, then it will be a very much streamlined process. And at the end, instead of filing county, you just file a motion that says we're done and we didn't ever get the assets, and so we're asking to have the case dismissed, terminated. So that's going to be really helpful, I think, to practitioners who need to file these no asset estates. And I should say too, in the small estate realm, if any of you have done small estates, one of the rubs in small estates is that when you go to a bank or when you're dealing with a transfer agent on the East Coast to try and get someone's stocks transferred, small estate proceeding, they insist that they need something called letters testamentary or letters of administration. And our response out here is, well, we don't give you, that's not an aspect of a small estate. You don't get those in a small estate because the court is actually not passing on the will or passing on the identification of the beneficiaries. It's basically a non-intervention kind of proceeding. So you don't get a court document that says anything. Yet the statute, the small estate statute says that an affiant this final small estate has the authority, and that the person who's holding assets or owes the debt to the estate is required. So it's always been a tug of war, between that and the statute, and trying to persuade another state bank council or another state, transfer agent to acknowledge the power of a small estate affiant in Oregon. And not surprising that the affiants typically lose, in that, and end up having to file formal probate just to get a document, that letters testamentary, or letters of administration, when they otherwise don't need to. So, our fix here, we'll see what the effect of it is, to authorize the affiant in that case to invoke the power of the court to require the transfer of assets if somebody's holding assets and refusing to deliver them to the affiant, and including attorney fee provision if the party is found responsible for not transferring assets when they were required to under the statute. So we're trying to, we couldn't persuade the courts to give us something, the judges, to give us something like letters testamentary, that look like letters testamentary enough to satisfy a bank or a transfer agent. But we thought that giving affiants the ability to, threaten a legal proceeding that could result in award of attorney fees to somebody withholding assets from an affiant that they're required to turn over under the law, that might give them a little bit more bargaining power. So we'll see. But good work on that. It's a pretty amazing work group. All right, and then we are to unless there's any questions about that, we'll have to say none. It'll be the no asset probate, the wrongful death, and then we'll finish up small estate with bills.
Yeah, we're carrying up 3 bills to go through this session.
Yep. Okay. So, PK, do you want to give us a status report on the workplace harassment?
Absolutely. Thank you, Mr. Chair. And I'm sorry I'm not able to join you today. Since our last group meeting, we've made tremendous progress in this effort, and I'm very pleased, because there were moments when I was truly having a heart attack, wondering if we were going to be able to meet the very tight timeline that the legislature had asked of us. Since about the middle of the year, we've put together a tremendous work group, including folks from the plaintiffs and defense side employment law bar, some lobbyists, former legislatures from both sides of the aisle, former staffers, people who are very skilled in both training and investigations, former Supreme Court Justice Jack Landau, people from BOLI. I mean, it really is a tremendous group, and we've all learned quite a bit from each other. And I don't think we could have come up with what we've come up with so far without the efforts of all of these people. So I truly commend them. Since we've met about, as Sandy said earlier, about 10 times. We have considered the best practices in addressing racial, sexual harassment. We've considered impact on victims. We've considered due process for respondents. We've looked to see how other states deal with some of these issues in other legislatures. We've taken as much public testimony as we could induce to come and speak before us, including some folks who were involved in the most recent issue in the legislature involving a legislator who was accused of harassing others. And then we've addressed at some length some of the constitutional issues that are involved with disciplining legislators. And we've worked on a continuing sort of evolving consensus document that we've published online after every single meeting. And so we've been getting public feedback throughout the course of our deliberations, and we've been incorporating that as we go along. As of our last meeting, which was yesterday morning, we have come to a consensus on almost every issue, which is really surprising to me and welcome. There are only 2 issues that we don't have complete consensus on, and on those we're going to present both sides of the issues to the legislature. So because of the tight timeline of this process and the unusual nature of this request, we're not going to be proposing legislation. We are going to be providing a report with recommendations about what the legislature should do. At our next meeting, we're going to be taking public comment on our draft recommendations, and we're going to be working on a plan by which the legislature can actually go about implementing our recommendations. We are expecting that we will have a draft report for all of you to review. We're going to provide the draft report to you rather than the final so that you will have additional time to look at it. Our timeline requires us to have a report to the legislature by the end of the year. Our final meeting will be December, I believe, 17th, and we'll approve a final report then, and we're hoping to have a telephone meeting with the rest of you to discuss that final report and hopefully get the commission's approval of the final report just before Christmas. Happy to take any questions.
Great. John, PK, this is Johnny Lorenzo. Thanks for all the work you're doing. What's the area over which there's no agreement on?
There's two areas we don't have agreement on, John. The first one is what is the, if you will, statute of limitations going to be by which the legislature will not take complaints. The current rule, which is Rule 27, requires that they won't take complaints that are more than a year old. We all agree that that is far too restrictive. The debate among our group was whether there should be a 4-year statute of limitations or whether there should be no statute of limitations at all. I think that the debate between that is really a risk assessment. I will disclose my point of view was to have no statute of limitations at all. My view was that an employer, as the legislature is in this instance, should always be willing to take complaints about harassment for the purpose of improving matters going forward. I think the opposing view is also very valid, and it's that, you know, at some point, particularly in a politicized political environment, there needs to be some cutoff, and it is, of course, difficult to defend against allegations that come many, many years after. So that's the first area in which we don't have consensus, and I think the group was fairly well divided on that one. The second issue is we are going to be recommending that there is a group, a new office within the state capitol that is there for the purpose of taking complaints, helping people figure out the complaint process, and establishing training. I think the vast majority of our group was comfortable with that recommendation, that it be an office inside the legislature. There was a dissenting view which basically held that pretty much everything should be outsourced because nobody in the legislature will trust an internal office. So those are the two areas that we disagree on.
Well, PK, if I can just take the opportunity to express my view on the statute of limitations.
Persons will come to us for final review.
Right.
Yeah, but go ahead.
Maybe it'll be helpful.
Yeah.
In areas involving sexual violence, I just cannot fathom why we should support a statute of limitations. The purpose of the statute of limitations, when I went to law school, was I was told that it's because memories fade and documents disappear, and it was evidential. It was not designed to let someone off the hook. And I think too often people think in terms of letting someone off the hook with respect to the statute of limitations. Today, when, you know, electronic media just does not disappear, and memories are still memories, it seems to me that there's really little reason to impose a statute of limitations. I think quite often the statute of limitations just interferes with justice, and so that's just my own personal.
Well, in this case, not to get into that debate, but we're talking here, this is not criminal sanction or proceeding, so there's that as well. The consideration may be a little bit different if we were talking criminal, but yeah, we'll rely on the report. We'll look at that, and really, surely the commission will have the opportunity if PK presents us with alternatives in our final review. The commission is well within its authority to pick one and go and make that final decision. Or, you know, we've done it before, offer alternatives to the legislature, especially in this case, since we're not presenting a bill. But,
PK, this is Judge Bushong. You mentioned that BOLI is participating in this process. I'm glad to hear that. They recently filed some litigation in my court on this subject that I don't know if this is going to if your work is going to resolve that or moot that, or if there's been any discussion of that. But I'm only thinking of it in terms of the resources of my court and whether I need to devote resources to that litigation or not. So do you have any information on that?
Judge Bouchon, we've been very pleased to have Amy Claire from BOLI on our group, and she's been very helpful. The view that our group has taken about our work, though, is that it's not going to figure out whether or not there is legal liability on any particular issue. The charge given to us from the legislature was to determine internal policies and procedures by which the legislature would itself address concerns about harassment. So, unfortunately, I don't believe that your court's going to be off the hook on that issue.
Yeah, and the litigation doesn't involve legal liability. It did involve whether or not legislative leaders are required to comply with BOLI subpoenas for information about that very subject. So I don't know where that goes, but
that's also not an issue that we have been addressing.
Okay.
So you can help us figure that out.
Okay.
Yeah, or not after the end of the year, who knows? Okay, any other comments or questions for PK? PK, I think I've said it before, I'll say it again on the record, how lucky we are to have had you come on the commission just in time to catch this month. And I think you're bringing it back for a score. Your expertise in this area has been invaluable to the work group. I've sat through a couple of the group meetings and really applaud your ability to marshal diverse interests and viewpoints through this to get to the point of consent, the extended consensus that you have. So on behalf of the commission, thank you for your work.
Thank you, Mr. Chair. It's been a pleasure.
She says it now. All right, that takes us through just the reports on our current projects. We have a couple new ones coming up. Is there anybody on the phone for the LLC Act?
Yeah, this is Valerie Sasaki. I was San Jose and Cantor, and I head the Laws Committee for the Business Law Section, and I'm incoming chair.
Great, Valerie. Do you want to just lead the introduction to the consideration for this proposal?
I'm sorry, I'm having a little bit of difficulty understanding you, but I'm happy to give an introduction if that's what you would ask for.
Yeah, that's what I asked for, sorry.
Oh, no, sorry, it's just the phone, I think. So one of the things that we've been looking at over the last year and a half as a section is a proposal that you all have to update the current LLC Act for Oregon, which was adopted back, I believe, in the early 90s. And has been updated sort of piecemeal since then, but the Model Act has moved pretty far away from where we are now. And so Oregon is actually out of conformity with the revised Uniform LLC Act, which is the current Model Act, which creates difficulties when we're advising businesses with multi-state presence or, advising businesses on where to form. So, one of the things that business law feels is very important is to be able to create an environment that will work and a legal system that will work given where we are today as a legal culture. And, so what we had proposed and what you have in front of you is our proposal to, form a work group that is composed of folks who bring a really diverse group of perspectives and, then, explore modernizing the Oregon LLC Act and adopting the revised Uniform LLC Act, which is the current Model Act.
Thank you. I want to acknowledge this was a conversation that has gone back several years. Under former leadership in the section, there was some reluctance to get into the Uniform Act. A couple of years ago, that all changed. They came to the Law Commission asking the Law Commission to take this on very happily. And that was about the time that we hit our transition period. So once we said yes, well, we've been sort of sitting on this for about a year and a half. So I'm happy to finally get to the point where we can move this forward. And I would say too that there are several. The Uniform Law Commission has gone through several business statutes or acts in the past 10 years And I think the plan is to start here with the Limited Liability Company Act, get that under our belts, and then look at, if I'm not mistaken, the Corporation Act, and then ULC has unincorporated associations, limited partnerships, there's a whole, again, acts on all the business entities, and then what they call the hub, which is sort of a central statute that provides common definitions and processes related to formation and other issues among all of the entities. And so it's a really very, very cool kind of structure, and I think the idea here is to use this as an entry to that and really look at our whole set of business entity statutes. Am I going too far on a limb in saying that?
No, that's absolutely correct. And that's why it's so important to the section that, you know, we get the right people and that this process is, you know, as collaborative as possible, because we want to get the right answers when we're talking about the hub that's going to form the basis for the future discussions.
Great. Well, thanks again for your support for this. This could be the new probate project for a few sessions. But it's really important work. And one thing you didn't mention, I think you said at the program committee too, was nothing compelling is that all of our neighbor states have adopted the Uniform Act at this point.
Correct.
So it's not just a matter of being out of conformity with Missouri or Florida, but you know, even entities that cross the river to Washington. We've got the ULC Act in Washington, California, Idaho. I think don't wait, and we're out of sync with our neighbors.
Yeah, Washington adopted something that's similar, but not exactly the revised Uniform LLC Act in their process. So, you know, they're a little bit out of conformity, but they've certainly looked at these issues in the last couple of years.
All right. Well, is there any further discussion? If not, I would entertain a motion to authorize the formation of a work group to draft the revised Uniform Limited Liability Company Act, and authorize the chair to appoint a work group chair and a work group to get going. So, all right, any discussion? Any objection? Hearing none? That is carried. Thanks. Last thing we have is the Uniform Law and Notarial Act. I'll just take that since it's kind of an orphan thing, but I wanted to get it going. This is another update. About 5 or 6 years ago, we adopted the revised Uniform Law and Notarial Acts. This is an amendment to that to deal with electronic notarization. It's, you know, just sort of a nod again, kind of like our e-hearsay, and things are moving, technology is moving ahead, things that we were not able to do in years past. We now have technology to do, and that includes remote notarization, authentication, and identification, all built into the process. There is technology that does this. And so the Uniform Law Commission has adopted a fairly straightforward and short amendment to the Notarial Act statute that accommodates this technology and the ability to do these remote notarizations. And so this would be a modification of our statutes to bring us into line with that and enable remote notarization here in Oregon as well. And my sense would be to, as best we can, reconstitute our notary work group. Again, those folks have changed, but we certainly have stakeholders identified. My hope is that, kind of like with special statutory proceedings, 1 or 2 meetings, we could have this done. Any questions?
Actually, I do have a question on that. Through our search warrant process, we occasionally are doing them by telephone from a remote location. We're not notaries, but we are giving an oath to a law enforcement officer, and then based on that affidavit, we would be making a decision on whether to issue a search warrant. So my question is whether or not this would affect that at all.
I don't think, that's a good question, and I'll ask Sandy to note that. We'll look at that. My recollection was that you, for those purposes, are already exempted from the Notary Act.
I think that's right.
I think you are.
I hope we are.
Yeah.
From my, when I was thinking about this along with Lane, I looked into that act. It did not appear to involve law enforcement at all.
Yeah, courts and judges are not notaries under the act.
Exactly.
Yeah.
Good. Okay.
We'll, if not, we'll include Sean.
But I definitely made a note, and I'll make sure.
Yeah, because I
Appreciate that.
because otherwise you'd be having to comply already.
Yeah, we don't want to do that.
Notary Act and keeping your journal and all of that notaries get to do. So I'm guessing you're already exempt. I think that's the case from when they did this several years ago. So if there's no, questions there, I'd entertain a motion to.
Just one note, I spoke to, I know there is interest, my conversation with folks at the Bar Association, I know there's interest, from various banking entities in particular. So just to make sure that when we form this work group, that we're, that various types of banks are represented, whether it be credit unions, whether it be commercial banks,
You and I will work on that, and soon, I think they were involved in the last
I think so.
version, but that's, well, they would be big users of this, I would think, or at least consumers, other people who have used it. Okay, then I would entertain a motion to approve the formation of the Uniform Law and Trail Acts Work Group, authorize the chair to appoint a work group chair and, work group members.
So moved.
Is there any discussion, any objection? That motion carries. So again, on both of these, the LLC Act and the Notarial Act, I welcome volunteers for chair, of these work groups. They're both gonna be a little bit straightforward, because we've got a uniform act already. We're not writing, unlike, hearsay and digital evidence, we're not writing a completely unclean slate. That's not to say it's easy, but, I hope, someone will think about that and let Sandy or email address to be chair of one of these two work groups. Items that takes us to the end of the agenda, except to acknowledge that we will be trying to schedule probably a phone meeting. We'll try and get a location for those of us who are able, but otherwise, a meeting by, most of us may be calling into to go over the, workplace harassment report.
Yeah.
I understand you get the draft, you get the draft first, we won't be reviewing that, that's just gonna be to bring us up to speed, knowing the proposed final report, is that it?
PK, you still there?
So we are going to be sharing a draft report with you for the purposes of having you be familiar with the issues earlier on. We will then be sharing a final report, at least out from our subgroup, to all of you before the final meeting.
Okay, and the timeline is to give this group adequate time to review, to have a discussion prior to that meeting.
Yeah.
We discussed the timeline yesterday. December 17th is the final work group meeting, but hopefully at that point, we'll have input from all parties, so we should be in good shape.
All right.
And what I'll do is keep an eye out. I'll be emailing for scheduling for that remote meeting, and as Lynn said, if you'd like to come in person, I'll make sure there's a room available. I know a lot of people are traveling that time of year, so we'll make it a short phone and/or video conference meeting with the sole agenda topic being this particular project.
Short, unless we get into
Well, that's true. Maybe
a little bit of discussion about.
But there will be one.
Yeah, there will be one.
Yeah.
All right. Well, is there anything else that you have before the commission? Otherwise, we've completed our agenda. And thank you, everybody. It's good to see you. Hopefully now with the commission getting up to speed and moving these projects through, we'll be seeing more of each other in the coming year. We'll get these work groups up and running as soon as we can. Again, if you have inspiration to be involved in any of them that we've talked about today, let Sandy or me know.
Yeah, and my only thing to add,
Meeting in about a month, well, it's probably the latter half of December.
You want to look at calendars, yeah?
I don't have mine. Well, we don't have everyone here, we'll just get the email out. Yeah, probably sooner than later.
oh yeah, I'm gonna get that scheduled week out, probably early next week.
Okay. All right, so, thank you, everybody, have a good Thanksgiving, we'll see you in December.